1 year ago, the ASP was at the height of the process of selecting a new prosecutor, and one of the recurring elements in that discussion was the need for more robust vetting. Heeding this call by a number of states parties, the Bureau launched this past April a lesson learned exercise, the selection process of the third prosecutor, an inextricable dimension of which is the establishment of a vetting mechanism of the court, not just the prosecutor. So at this point, we have a process under to examine ways to strengthen the prosecutor selection process. The issue is embedded. We have also had some developments related to vetting that have occurred in parallel to, of course, to the due diligence of the recent selection process. In addition to the experience of performing due diligence in respect of candidates for deputy prosecutor, the facilitators of the lessons learned process, who are now appointed and who are tasked with submitting a report ahead of the 21st session of the ASP, also have a number of other reference points to draw on. They have reports from the Committee on the Election of the Prosecutor, of the third prosecutor, from the panel of experts of the same process, from the former ASP presidency, also in respect of the same process. They have position papers from states parties and from civil society. And of course, they are themselves expected to consult widely with all stakeholders, including on the vetting issue. What we need to do now as states parties, whose primary objective is to protect the court, is that we finally are able to shape and agree on a permanent vetting mechanism, which ensures that all shortlisted candidates put before the ASP for high-profile positions of the court, in the court, do in fact meet the Rome Statute's high moral character criterion. We are currently trying to include some language to that effect in the ASP Omnibus resolution, which is under negotiation. In addition to decide to have a vetting mechanism in principle, a number of other questions ensue. Firstly, which ICC officials should this vetting mechanism apply to? Secondly, how do we adjust the level of vetting to the different selection processes for different officials? Thirdly, which entity is best placed to conduct the vetting? What does the vetting consist of and how is it done? How are complaints against candidates submitted and how are they handled? How are reputational issues probed during the selection process? Who makes the final decision regarding the credibility of complaints alleging misconduct? And what is their bearing on the candidate? How do we ensure that due process is respected? And how do we ensure confidentiality? Of the above questions, we have a panel today that can help us reflect on the question of the vetting entity, as well as what a vetting process consists of and how it's done. Though our panel are, of course, very welcome to express views on the entire spectrum of elements that we need to consider in construction. So without further delay, I give the floor to our first speaker, who is Ms. Mariana, the Senior Legal Officer at the Open Society Justice Initiative, for her remarks. Thank you, Mariana. The floor is yours.
Thank you very much, Polly. And let me first thank the Permanent Mission of Cyprus to the United Nations for joining the Open Society Justice Initiative in co-sponsoring the side event. And I'd like to thank all of you in attendance today for joining. It is very significant that we are gathered today to talk about vetting for Icc elections. This matter had received no attention up until 2 years ago. Although Icc staff go through a process of background check and security clearance upon recruitment, before 2020, Icc officials had not been subject to any forms of checks. As we've heard, the Rome Statute requires that Icc judges, the prosecutor, deputy prosecutors, registrar, and if elected, the deputy registrar, be persons of high moral character. In the past, it had been assumed that any candidate met that requirement, but practices in other jurisdictions and well-known scandals in relation to the Me Too movement, among other developments, have confirmed that it is imperative to undertake proactive checks in the form of vetting. As noted, this became a live issue last year during the election of the prosecutor. The question had been omitted in the terms of reference for the Committee on the Election of the Prosecutor, but during the course of its work, the committee felt it was necessary to undertake some checks and engaged the services of the Icc Security and Safety section to scrutinize the candidates it interviewed. This practice was later on also reproduced by the Advisory Committee on the Nominations of Judges. In addition, last year, the Committee on the Election of the Prosecutor included questions in its interviews on the topic of workplace harassment, and it assessed the candidates' demeanor and substantive responses. In its report, it noted, however, that it lacked the legal framework, the mandate, and the capacity to receive complaints, to carry out investigations, or to conduct inquiries into allegations of misconduct against candidates. The committee added that it was aware that a vetting process set in motion ex post facto and with a limited scope could not lay claim to comprehensiveness, nor could it offer all desirable guarantees. In both its 2020 final report and its 2021 lessons learned report, it recommended that future selection processes for elected officials, and not just the prosecutor, for all elected officials, include a clear process for determining high moral character, and that process should be made known to candidates in advance, and it should be agreed by all candidates, and it should also include parameters for potential deep dives, the committee called it, in the event of serious allegations of misconduct. Many of you will recall that in the months leading to the election of the prosecutor last year, civil society pressed for full and thorough vetting, but no other checks were put in place after the Committee on the Election of the Prosecutor handed over its report. So with the end, the candidates, however, were asked to sign a declaration. Earlier this year, the Open Society Justice Initiative undertook research on last year's election with a view to contributing to the ongoing state party-led effort on lessons learned. We interviewed over 25 interlocutors who had been directly involved or who had closely monitored the election process. And with the benefit of those interviews and further desk research, we produced briefing paper to help states, civil society, and court officials draw lessons for the future. Let me emphasize that the briefing paper was not designed to render judgment about the qualifications of any of the candidates. Rather, our focus was on the process with the aim to contribute to broader reflection on how best to ensure quality, transparency, and effectiveness in selecting courts leadership. With respect to vetting, we gathered the following information. Respondents were nearly unanimous that the failure to vet all candidates under consideration was deeply regrettable. The committee's efforts and the inclusion of the Icc Security and Safety section were a welcome step, but did not constitute full and proper vetting, as the committee itself acknowledged. According to one candidate, the reference checks and the background checks were done very quickly, which raised questions about how thorough that the vetting process was. The same candidate indicated that where referees were contacted in writing, there was no conversation. References, and that included supervisors and supervisees, were asked to complete a form that was tailored only to supervisors. It was not clear if the process introduced by the Security and Safety section adhered to data regulations. One candidate, for example, requested to access the data collected about them, but the request was denied on the basis of confidentiality. The merits of that request and the subsequent refusal are not for us at the Open Society Justice Initiative to decide, but that incident highlights that due consideration should be given to the rights of all parties involved and to data protection regulations. With respect to the declaration that was introduced at the end, a number of those interviewed found that it was wholly inadequate. As pointed out by most respondents, it's very easy to sign a document and attest to one's moral character, but such a document neither proves moral character nor constitutes a true requirement. Another respondent pointed out that the declaration was limited because it did not cover the important factor of temperament. All in all, the lack of vetting in last year's election cast a shadow over the election process. The need to certify the candidate's moral character became increasingly clear toward the end, including in the 2-3 weeks preceding the election. The absence of vetting allowed rumors about the candidate's moral character to spread, leaving states with no tool to have any allegations independently verified. Last year's events, coupled with the setup of the due diligence process for the election of the deputy prosecutors, demonstrates, in our view, that there is a gap that needs to be urgently filled. In addition, states have proposed a due diligence process for the 2023 election of the registrar, according to the draft resolution put forward by the Study Group on Governance for adoption at next week's Assembly of States Parties. Clearly, the need for vetting will not abate. A permanent vetting mechanism rather than ad hoc structures created anew every time there is an election is more rational, cost-effective, and efficient. We would like to see a permanent vetting mechanism for Icc elections adopted as soon as possible. If the adoption of such a mechanism is delayed, so will its implementation. States parties risk every time they conduct an election without adequate safeguards. It is no longer acceptable to elect an Icc official without vetting. This practice protects the credibility of the court, the well-being of its staff, and consequently, their productivity. Before I close, I'd like to make a couple of remarks on a few of the points that were introduced in the beginning. First, what are the vetting components? What should be the vetting components? I believe other panelists will discuss this in more detail, but let me just say that vetting needs to be proactive. Just like any other investigation, it is important that it is designed to enable the vetting entity to gather as much information as possible on its own initiative. Many acts of misconduct, for instance, do not qualify as crimes and therefore could not be uncovered as part of a criminal record check and may not be independently brought to the vetting entity through a reporting channel, including due to multiple reporting barriers such as fear of reprisals, fear of exposure, fear of inadequate confidentiality, to name a few. Having a reporting channel is important, but it cannot be the main avenue for checks. Whenever such a channel is put in place, sufficient time must be allowed for informants to come forward, and the notice must be widely distributed, including within the professional circles in the countries where the candidates come from. Finally, who should be vetted? There's no doubt that judges, prosecutors, deputy prosecutors, registrar, and deputy registrar need to be vetted. As the Rome Statute says, they must be persons of high moral character, and that's clear. They all have public-facing functions, and their actions have an impact on the institution as a whole. Some oversee the work of entire organs and manage large number of staff. Together, they set the tone for the court's institutional culture. We recommend that the Assembly also introduces vetting for other officials, perhaps with a different sets of checks, including members of the ASP subsidiary bodies. All of these functions include a high level of responsibility, and it is necessary to exclude anyone with a history of misconduct, fraud, or corruption. I look forward to hearing the other two panelists today who have a wealth of experience on these matters. And I also look forward to a lively discussion with you in the audience. And thank you very much.
Thank you very much, for your contribution. I turn now to Ms. Fröhlich, partner at Mins Group, a diligence and investigations firm that offers a wide range of services in background checking, fact gathering, and internal investigations internationally. Over to you, Kelsey. We look forward to your remarks. Kelsey, you seem a bit frozen. Can you hear us? Is your connection? All right, I can see you're unmuted now. Yeah, we can hear you now. Please go ahead. Not quite. I think your connection might be a little unstable. Yes, it does say poor network. Maybe to give you a bit of time to deal with the network issues you're having, we can switch the order of the speakers a little bit and move on to Mr. Saklein Hederali, who is the head of the ICC's internal oversight mechanism, which is an operationally independent office within the court with a mandate to conduct internal court inspections, evaluations, and investigations at the request of the Bureau or the ASP. And of course, the IOM had a prominent role to play in the due diligence process for candidates applying for the position of deputy prosecutor. So, Mr. Hederali, please, you have the floor, and Kelsey, I'll come back to you after Mr. Hederali. Thank you very much.
Thank you very much, Polly, and thank you for the Permanent Mission of Cyprus, as well as the Open Society Justice Initiative for inviting me to this discussion. I was looking forward to hear Kelsey's experience and thoughts and how they could be incorporated, in the context of the court. So I look forward to hearing those. A couple of comments on this issue. First of all, the process that the security and safety section of the court does exist and does cover to some extent, and of course not fully, but it would be wrong to say that there is no process whatsoever and everyone at the court just shows up. So all the staff go through a very thorough process of background check. And it's not just a simple background check. It is an exhaustive one. But however, the focus is different. The focus there is any security risk that could bring to the court, and that does involve to some extent any reputational risk that could arise from previous, for example, criminal conviction. But of course, that is not what the process was designed to cover. And we saw the limits of that process, as was mentioned earlier in the election for the prosecutor. There's a few things that came up when we were discussing this due diligence process for the deputy prosecutor that I think is important to sort of mention. And one of the challenges is to design a process that balances the confidentiality to sort of complainants or people who would like to raise any issues and safety to them, fear of reprisals and so on. But as well, a due process for the candidates to make sure that they have a chance to respond properly. And this is even more important in that in many places, and that's what I was curious to hear Kelsey's thought on this, often these processes happen at the end. So the security section, for example, is at the very final stages. So the recruitment panel has done its work. They have essentially selected the candidate, and before making the offer, they enter into those checks. So the decision is already made, and this is sort of to make sure and really sort of to guarantee that there are no issues there. The problem with elections is that you have a process that has not yet given rise to a candidate that will be there. And what that means is that opens the door to people trying to abuse such a process and, let's say, inundate whatever reporting channel is with, for example, malicious complaints in order to sort of, favor another candidate. We saw some hints of that in the prosecutor election, where we saw some allegations that, if you looked at them, could be tracked to other candidates or so on, because although we did not actually engage in that process, when there were discussions about maybe involving us, we did take a look. So I think this is really one of the challenges in devising a process in the middle of a selection process with names that everyone knows, who are the candidates and the competitors. And that's why it's very important to have a robust process in place and a well thought out process. The other thing that I would say is also the value of the mere fact of having a process. As we saw with the prosecutor election, one of the big problems was, as was mentioned by Mariana, was that the fact that you did not have a way to actually resolve these issues left it open to speculation and rumors. And to this day, very few people, myself included, myself excluded, know exactly what the allegations were. But we all, I'm sure, have an idea of what it is from the rumors that we've heard. So the mere fact of having a process in itself, I think, brings some confidence and reassurance in this. Now, of course, what the process should include, what it can include, I mean, that's obviously a much more detailed discussion. What I will simply say is that the more this process is extended to more and more people, the more and more resources it requires. The reality is that, practically speaking, and I'm not just talking about the IOM here, because the IOM may not have a role to play in this in the future, but the reality is that in some national jurisdiction, for example, we know in the United States Supreme Court, because it's a well publicized process, you have the FBI carrying out a full investigation, going door to door, talking to former neighbors, former colleagues, and asking them, did he ever steal your mail, or things of that nature, which of course would be completely unrealistic in our context. If you have, for example, for the judges, 6 judges is being elected, maybe 20 judges being considered all over the world, it's just something that is not feasible. And that's why the due diligence process that was devised in the limited time that it had, and it has to be noted, was probably not a perfect process, but I think was probably, in the circumstances, as much as could be done given the time there was. I fully agree that there are other things, but I would not underestimate the importance of the confidential channel. And the reason for that is that that's what acts as your ultimate safeguard. You can have the most thorough process before, trying to make as many searches as you want. You will always, it's impossible to capture everything. And that's why, this channel provides a good safeguard that if something was missed, if something did not come up, it can capture that. Of course, it has to be, I agree, it has to be disseminated publicly, widely, people have to have enough time to be able, and they have to also understand what is going to happen to them when they sort of, do submit, let's say, a report or a concern about a candidate. And what's going to happen when the concern about the candidate is not about moral character. Many people may have concerns about a candidate because they don't think that that person should be qualified or should be in one of those positions. But that is something different than being of high moral character. So I think those are all issues that must be thought through. I could obviously go on about every single item and every single criteria and about the reputational interviews and about questions and declarations and consents and all of this. But I think that those really are details that have to be then discussed if there is a decision to institute some sort of permanent vetting process. But I do think that it has to be also balanced with, realistically speaking, what resources will be required for such a process. I mean, as many people we're in the middle of budget discussions at the court, and those are very difficult in the context. So, to try to sort of have something that would be too onerous, also will be problematic. So it has to be something that will be there, that will be helpful, that will be effective, and that will be efficient at the same time. And I think there is room for that if the will is there. And I will echo the mere fact that we are having this discussion right now shows how much forward the issue has moved since last year. I think everyone has realized that there was a problem, and you need something to provide everyone reassurance: the states parties, civil society, the staff, that the people that are elected in those very important positions come there with the proper background and the proper moral character. Which, by the way, is another issue as well. What is a high moral character, right? I mean, if someone is parking in his neighbor's spot, are they really of high moral character? I would say they're probably not a very high moral character, but I don't think that's what we're talking about here in the Rome Statute. So I think that's another thing that we have to deal with in terms of the criteria that are there and that have to be as well thought through. I will leave it here, and I'm eager to hear what Kelsey has to say. And of course, if there's any other points after, I'm happy to comment. Thank you.
Thank you very much, Jacqueline. And there's a lot in there that I'm sure we will come back to. But for now, let's go back to Kelsey, and hopefully your poor network issues have been sorted, and we can hear what you have to say. Please, the floor is yours, Kelsey.
Third time's a charm. Is that any better? Success. Fantastic. Well, thank you all for bearing with my poor network issues. I'd say that's a unique issue, but it's certainly not for me. So unfortunate timing. I'm sort of glad that I dropped out there for a moment and came back, because I'm quite interested, I suppose, to follow Jacqueline's comments. I should start by saying, maybe perhaps introducing myself. I'm with a firm called the Mintz Group, which is an investigations firm that conducts detailed internal investigations during disputes or after claims or issues have arisen, and also designs vetting mechanisms and also conducts quite detailed background investigations for international organizations, for publicly traded companies, for things like that. So have conducted thousands and thousands of background checks all around the world, but of various different levels. I should make it very clear that my comments here today are very much based on experience of having conducted these background investigations for international organizations and their clients. They're in no way targeted to, or in fact even knowledgeable about, the Icc vetting process. So I know almost nothing, and in no way am commenting on the process that went forward. Much more just trying to offer, I suppose, some best practice based on what I've observed from doing this type of work over many years. But it's clear to me after hearing from Jacqueline that I want to throw out some of the comments I was going to say as a starting point, because what I wanted to talk through was sort of the the sort of detailed and levels of background investigations and vetting procedures that you could set up, and talk through that from sort of A to Z. But it sounds like we can skip A and B and move on to the much more involved processes, because it sounds like we're more advanced in our discussion today, which is fantastic. I think that the investigations industry has in some ways done a little bit of a disservice in obfuscating, or perhaps not always being completely transparent about what goes into a background check. And I'll use the term background check quite broadly. But in fact, a background check could be something as small as the type of check that you would do when you get an apartment, or get a loan to buy a car, a criminal check and a bit of Googling, and maybe a credit report, up to and including something that is much more involved than that. I want to talk a little bit about what those steps entail and sort of when you would bring them into the process, but let's all agree that it's very much a gradient. A vetting process can be this much or to the end of the earth. And of course, the amount that vetting entails has to be targeted to the position in question, to the amount of resourcing available, and to the realities of your organization's appetite and privacy restrictions. So it's incredibly complicated, and I just want to acknowledge that from the outset. As I said, I'm kind of throwing out some of my notes here, but let's talk through in really broad strokes what a vetting procedure could look like. The sort of basic level, as I said, could be that very quick kind of tick box exercise. I don't say tick box in a pejorative way. That's totally appropriate for certain types of roles and certain types of relationships. Of course, we don't all have infinite due diligence budgets. And if you're applying a vetting process to a broad variety of positions, you have to create a much more targeted mechanism that is appropriate for those positions and also in line with what resources are available. A more detailed, but let's call it kind of a medium level, could be much more involved, but still by no means everything that could be done. A more involved vetting mechanism could include not only criminal records, which as one of the other speakers noted, many things do not get elevated to the level of a criminal complaint or criminal investigation. I could also include looking at civil litigation, looking at regulatory issues, looking at issues at the candidate's previous company or previous position that could speak to their stewardship. If a candidate has led a department or led an organization, and that organization has been the subject of allegations that it has a particularly horrible work environment, or an environment of bullying or harassment or something like that, those sorts of things could speak to the candidate's stewardship and leadership in that role as well. So that could be included within a more detailed vetting procedure. Certainly, we want to focus very carefully on things like social media. I know we can all think of many examples where folks have been brought down by comments they may have made on social media, even those that may seem on the face of it, less than inflammatory, but would certainly need to be vetted and looked at very carefully, especially in line with the specific position that the subject is up for. Also, we've found that in many instances we're spending a lot of time on this more detailed vetting process, looking for the types of sources that may not be totally obvious. And what I mean by that is that there have arisen over the years specialist blogs and forums and groups of people who have, invested time in raising allegations and, allegations of harassment and sort of bad workplace practices, to bringing them to the forefront. And those could be blogs and publications that focus on a specific industry or a specific organization or a specific institution. And those things, again, must be vetted and looked at carefully, because these are allegations, and we should understand the substance of those allegations. But looking at that and being aware of those issues before we get too far down the road in the process can help prepare and help us to just determine what further investigation might be required. another source that we often find is quite important, and I alluded to this a little bit, is looking at the environment and the issues in the organization that a candidate had led previously. So it may be the case that a candidate has some sort of baggage.
We seem to have lost Kelsey. Let's give her a minute to reconnect. Kelsey, are you able to hear me?
I think she may have left the meeting. Maybe trying to reconnect.
Let's hope she can rejoin and resume. But perhaps while we wait for her to do that, I had a question for Sakling that I was saving for later. But you mentioned, Sakling, that it's more challenging to do the vetting when you have, and correct me if I'm wrong, when you have an election or a selection process, and we're not talking about the regular ICC stuff that you vet on recruitment. And I wanted to ask you about the possibility of vetting once there is a long list of candidates. For example, in the prosecutor selection process, we had a CEP and a panel of experts. They went through the applications. They produced a list of possible candidates, and so before they started to interview those candidates, would it be possible to have a vetting process then to be a little bit proactive, as Mariana was mentioning before?
Thanks for that. I think it is. I think we have to remember there's different parts to this process. For example, in the due diligence process for the deputy prosecutor, there were two stages. One stage was while there was a sort of long list, if I may say, provided, and then the process of doing some of those background checks, to call it broadly. All of that can, of course, be done, and if the resources are permitting, that's a good idea to do, because it does provide for information, and some things could come out of that process. But I think that you will not, you would be jeopardizing the process for that second part if you did that too early, which is a confidential reporting channel. As I said, I think this is fundamental because that will catch really the things like if, again, I'll give the example of the U.S. Supreme Court simply because, it's fairly fresh. But when the last justice of the Supreme Court, someone raised an allegation, as many will remember, very serious sexual assault allegations. And they said themselves, I never raised this issue before. I raised it now when I saw that this person is being considered for the Supreme Court. So therefore, no background check would probably have uncovered this without the person coming forward. So that's why that reporting channel is important, and that I think has to be kept as far as possible. I mean, ideally, it would be ideally after the selection has been done, but you can't do it after the election, because then what do you do if something does come up? You cannot wait another year for the next ASP. So this is why the question is a bit trickier than, if there were to be a more thorough process than what is now being done by the Security and Safety Section for staff members of the court, for example, like directors and other high positions, then perhaps that's something that could be done in those cases, because then, worst case scenario, you can always go back to sort of whoever was second on the list. So I think, yes, there is some things that can be done early on, and I think it does make sense to build that in the process to help, make sure that if there are any big red flags, if someone has been convicted of corruption in a state, well, might as well know that early before that person gets shortlisted. So some actions could be taken. What I was really talking about was this final stage of this reporting channel and the challenge that it brings while the selection is in a way ongoing.
Thank you very much, Sakleen. I don't know if we have Kelsey back with us. I saw that she rejoined at some point, but probably her connection is not stable enough for her to proceed. So let me throw out another question out there, which very much concerns the IOM directly. And that is one of the questions that have been we've all been asking ourselves is whether the vetting entity for ICC elections could be the IOM, or whether this process should be outsourced to a private company. And I wanted to hear your views, Sakleen, as to whether you feel there's any difference in the capabilities of the IOM versus a private company when it comes to conducting the necessary background checks and investigating allegations. You spoke about resources before, but I'm assuming that the resources are there. What would you say that there are any differences in capabilities?
Well, thanks for the question. I mean, that's a very big assumption, first of all. But taking it on board. I mean, I think in terms of any allegations being made through a reporting channel, I think it is very similar. I mean, if we get an allegation of, sexual harassment, I mean, we would treat it similarly as we would treat the allegations that we would get internally. Of course, the difference is that our means are more limited, right? We will not have in many cases the power to compel information from another organization. We need to have some consents and so on and so forth. So I think there is a challenge there. There may be historic allegations as well, which are more difficult, of course. But in terms of the nature of the work, that would be very similar. So I think and that's why I think in the end, the Bureau of the Assembly decided for the Deputy Prosecutor to entrust that part to the IOM because it made sense, to see if it could work. On the other aspects of it, in terms of sort of like let's call it more the background check aspect, if I want about sort of doing research and finding information and sort of, researching and reference checks or criminal records and all that. I mean, I think it's not, I don't think it's not really within the mandate, but I don't think it's something that is also exceedingly onerous. What we have done for the deputy prosecutor election is that we've asked for the registrar, we've asked the assembly to instruct the registrar to sort of assist the IOM in that part, essentially. So the safety and security section for this exercise reported to the IOM and conducted their work with some modifications to what they usually do. So I think there is room there for, without reinventing the wheel, for the IOM or for any other entity to play. Really, I would say that it's natural for the second part in terms of the allegations, whereas the first part, I think it could or it could not. I mean, there is an advantage, of course, that the IOM has some independence to it. So if we talk about an elected official, someone in the registry section, for example, may be a little leery of sort of like, asking questions or digging into sort of who their ultimate boss will be in the future, for example. So I think there could be a role to play, but of course that's not for me to decide, and that's a discussion that we've had with the state's parties for the deputy prosecutor election. And it's a discussion that we will continue to have if we're asked that question about what can and cannot be done when we discuss the issue of for example, the next one is the registrar elections was mentioned before, or if there is a more permanent process set out. I'm sure that in that case, we may be consulted, and then we'll see. But the issues are sort of there. So I think it does make sense. But of course, you are also changing the mandate of the IOM. You are adding to it another element that is not there. So that also has to be considered. So that the mandate which was revised last year has to be probably as well amended to include that, which is obviously not impossible to do, but I think a lot more thought has to go through it. I think the first decision would be sort of, if you want to have a vetting process, then it is what that process should be and who should be conducting it would be logical following questions.
Thank you, Sakleen. And of course, yes, this is, as I said, one of the main questions to be considered. And I think this is why this event is so useful, because it's giving us insight as to how these things are done and what the capabilities of an internal mechanism versus an external company have. I'm assuming that we've lost Kelsey because I don't see her. I see that she's been trying to rejoin the meeting, but I don't see her in the meeting right now. So given that we have only a few minutes left, let me open the floor for any questions from participants at this point. Also perhaps to throw out a last question out there myself is, it would be interesting to know how allegations that have been made against someone in a different jurisdiction are dealt with, especially if there's a lack of sufficient information or cooperation from the authorities in that jurisdiction that are not perhaps optimal. But before coming back to you, Sakleen, I think Kelsey, are you back with us?
I am back with you, and I apologize 1,000 times for my terrible technical difficulties.
A huge amount of time left, but I think it is useful to to hear the rest of your presentation. So please, if you can pick up from where you left off.
Sure. And I'm aware, because I've heard much of the conversation, that perhaps, our conversation may have progressed from here. So I suppose I'll pick up kind of in the middle. I was speaking about there being a sort of gradient of options available in terms of conducting the, quite detailed vetting process. And I'd be very happy to go through options at sort of earlier stage, later stage with anyone, as appropriate. But I think maybe I'll kind of add the point that there may be more opportunities available than you know about. There may be more resources available for a vetting process, or sort of earlier in the stage vetting process than might be apparent by calling something just a background check. Sorry, it's a little bit awkward that I'm jumping in here at the end of the conversation, but I'd be very happy, I suppose, to jump forward to any questions if I can contribute anything from the perspective of someone who conducts, quite detailed investigations earlier in the process, and also in response to bottoming out allegations, if appropriate. Do you mind if I just sort of leave it there?
Thank you, Kelsey. A question that I put out there for Sakleen, and of course it goes out to you as well equally, is how you deal with allegations that have been made against someone at a previous workplace or in a different jurisdiction, and how do you overcome the lack of sufficient information or cooperation from authorities in a different jurisdiction if you find yourself in that situation?
Sure. Did Sakleen already take that one, or shall I jump in?
Well, Sakleen hasn't had a chance yet, but please go ahead, since you have the floor and your connection is working. Maybe we should take advantage.
Thank you. Apologies, it's so awkward. So I suppose we're to assume that there's a variety of allegations, of which some it may have a variety of different levels of merit. And I think that is an important starting point to the answer to that question, because certainly it is important to have a procedure in place before allegations emerge, whereby you would triage such allegations. You may have a procedure in place that says you treat every allegation with the same level of follow-up investigation. And you can imagine, depending on volume, that could become quite involved. However, if there's a volume that's more accessible, you may have the resources and the time resources available to, dig deep into every allegation. It's important to understand how one goes about digging in every jurisdiction. I think that jurisdiction shouldn't have too much of an impact in terms of follow-on investigation, but appreciate that the level of data and public records and such that are available in different jurisdictions can vary very widely. So, in my perspective, in terms of having, conducted sort of, completed rather, triage response systems for a company, for example, we would always strive to treat the follow-up procedures based on the seeming merit of the allegation, based on some predetermined parameters, rather than letting jurisdiction determine the level of follow-up. And again, appreciate that can be somewhat difficult, but there are mechanisms available to get information and to conduct interviews everywhere in the world. So, it behooves us to aim for some consistency where possible.
Thank you very much, Kelsey. Before I turn back to Sakleen, I have Elizabeth Evanson from Human Rights Watch. So perhaps we can add a bit more questions, give the floor to everyone who wants it before coming back to the speakers. So Elizabeth, please go ahead.
Thank you very much, Polly. And I just wanted to thank all of the speakers for this really helpful conversation, which I think has pulled out some of the complexities of doing this vetting, but also speaks to really the necessity of having a strong process in place at the Assembly for ICC elections. And I actually wanted to share on behalf of the Coalition for the ICC's elections team, so not only Human Rights Watch, but the entire team, our strong view that there should be a permanent vetting mechanism set up by the Assembly for all ICC elections. We've been closely following the discussion in the omnibus facilitation, and thank Cyprus and other states parties for their proposals. We have put together a position paper. I'm going to put the link in the chat for those who haven't seen it yet. But essentially, rather than developing these ad hoc procedures, we think it's time to move forward and have a permanent mechanism to vet candidates. And so we are really looking to the Assembly at this session in the omnibus resolution to adopt language that would put in place a firm commitment to have such a mechanism adopted by the Assembly's 21st session. And we welcome the fact that the language proposals have reflected the importance of consulting with civil society and other experts like those we have here from the IOM and from the Minsk group. We do know that in the discussions on the omnibus resolution, there's been some concern about not predetermining or jumping ahead of the lessons learned processes that are going on with regard to the prosecutor election. We think that concern can really be addressed and that the language that's currently under discussion in the omnibus does make clear that this process would benefit from the outcomes of as those processes proceed. So thanks very much for giving me the floor. I just wanted to share that on behalf of the elections team, and I'll put our position paper in the chat.
Thank you very much, Elizabeth. Well, perhaps given that it's already 11 a.m., Jacqueline, can I come back to you for any final thoughts, and including on the question that was put out there?
Well, on the question, I would agree with Kelsey that jurisdiction should not decide how an allegation is handled. For example, what we did find very useful in this process for deputy prosecutor election, and the advantage that we have, as opposed to maybe some of the investigations that are conducted privately for other issues, that we have the candidates. And I think one way that we have found that can obviate a lot of the issue is to simply seek their consent early on, that we would contact all of their employers, all of wherever we needed, and that they would give us that consent, to resolve any of these issues. That may not be applicable to maybe a state official, a government official, like a prosecutor office or a police force, for example, but definitely for former employers, that would usually alleviate their concerns about sharing information that they think they cannot. If they have the consent of the person who was involved. And of course, here we're talking about if there had been allegations made previously in another workplace, for example. So that's really the question. And for the rest, I don't have any final thoughts or comments. I would simply just say that I think that we have seen what happens if with the prosecutor election. I think that, again, and I may be repeating myself, but having a process in itself has some value. Now, what that process is, whether it's ad hoc, whether it's permanent, whether it's different for each position or not, that's a separate discussion. But I think having something in place that provides some level of comfort and reassurance, to people that at least that there was something and that, nothing has come up, for example, even that in itself has its value. And, if our help is needed, then obviously, we stand ready to help as much as we can, allowing our resources and our mandate.
Thank you very much, Jacqueline. Thank you for being part of this discussion. I think it has been very useful. I don't know if Mariana or Kelsey want to come back in with any final thoughts. If you do, just unmute yourselves and take the floor.
Thanks, Polly. Perhaps very briefly, because we're past the time, just to say that this conversation shows that there is a lot to discuss during conversations on the development of a vetting mechanism, that there are a lot of open questions, and it's just right because the body, if it's the Bureau or another body that would discuss how to set up a mechanism, would need to necessarily dig into all of those questions. So just wanted to thank everyone who joined. We had a very good turnout, and yeah, it just shows that this is a lively issue and that hopefully it'll get the attention it deserves next year.
Thank you very much, Mariana. I don't see anybody else seeking the floor. So I won't be making any closing remarks. I think this is part of an ongoing discussion. As Mariana said, there's a number of issues to unpack here in the effort to design a vetting mechanism which we all want, of course, to be comprehensive, and we want to get it right because it's important for the court. And with that, I'll just thank everyone for joining us today. Let's continue this discussion. It's up to all of us to make sure that we come up with the best solution possible for the court, knowing, of course, that this is going to be a living mechanism that should always be updated to meet the highest standards. So thank you very much for joining us today, and looking forward to seeing you all in the next chapter of this discussion. Have a great day.
Thank you.